name's Jonathan Svitak, and I'm an attorney with the Shannon Law Group, and I'm the head of our vaccine practice. And what we do is we pursue compensation for people who have experienced an injury or a side effect due to a vaccine. And we do that by filing petitions in what's called the National Vaccine Injury Compensation Program. So let's say you're injured by a vaccine, and let's say, for the sake of an example, you get a flu shot and you develop what's known as Guillain-Barré syndrome. Now, the process by which we go about investigating these claims, we have to determine certain things before we file a petition. And the first would be whether the vaccine you received is actually covered under the Vaccine Injury Compensation Program. In our example, the flu shot is covered under the program, so you would be okay there. But there are certain vaccines that are not covered under the program. So that's the first thing that we have to determine. The second thing we have to determine is whether or not you received the vaccine within the United States. That's a prerequisite to getting compensation in the program. There are a few exceptions to that rule, and one would be as if you were employed abroad or part of the United States military and you received a vaccine in a different country. Under that scenario, you would also be able to file a petition in the Vaccine Injury Compensation Program. Also, if you received a vaccine while you were abroad and it was manufactured by a U.S. manufacturing company, and you returned to the U.S. within 6 months of receiving that vaccine, you would also be eligible for compensation and be able to file a petition. So those are the two main exceptions to that rule. Also, the other rule, before you're eligible for compensation in the Vaccine Injury Compensation Program, your injury must persist for at least 6 months. So that's something that we determine at the time of our intake process. We'll ask you about which vaccine you received, the symptoms that you're experiencing, and determine how long you've been experiencing those symptoms. If it has been ongoing for 6 months, you'd be eligible for the program. There is an exception to that rule as well. So if you are injured by a vaccine and you require hospitalization and a surgical procedure, there is no requirement that your injury persist for 6 months. So that's the one exception to that rule. And finally, there is a statute of limitations as well to these claims. So if you received a vaccine and you developed an injury, you must bring or file that petition in the program within 3 years from the date of onset of your symptoms. So in our example, if you received the flu shot and you developed Guillain-Barré syndrome about 2 weeks after that flu shot, you'd have 3 years from the date of your first symptom of that injury to bring a claim. And this unfortunately prevents a lot of the folks who call us from being able to file petitions, because not many people are aware of the program, number one, and not many people make the connection between their injury and the vaccine. So after you meet with an attorney like us and we determine that we are able to help you with a vaccine injury compensation petition, the next steps would be gathering all the information we need in order to file the petition. So first, we have to determine, obviously, the vaccine you received, where you received it, and get that vaccination record. We're going to have to find out where you received treatment for your injury and get all those treatment records as well. The court also asks that we file medical records for the 3 years prior to your vaccine injury, so we'll have to get those records. And we compile all of this information together and we use it to draft a petition where we make certain allegations. We allege that you received a covered vaccine, we allege that you experienced a certain type of injury, and then we tell the court about the treatment that you received for that injury and make sure that they're aware that your injury has persisted for 6 months. And there are a few other documents that we need to file along with the petition. One would be an affidavit from you, the petitioner, that corroborates everything that we're alleging in the petition. It sort of tells the court the story of your injury. We also have to file what's called a PAR questionnaire form. or a pre-assignment review form, and that's just a list of all the medical providers that you've seen as a result of this injury. So those are the main documents that we need to file, and the court will not review your petition and the evidence until they are certain that all of those documents have been received and that there's no other medical records, no other missing documents that they need in order to come to a conclusion as to whether or not you're entitled to compensation. So after we're able to get all that information we need for your petition, we file it with the court. We file all of your medical records, and we tell the court that everything is ready for their review. And we do that by filing something called the Statement of Completion. Once we file the Statement of Completion, the court, that signals to the court that the evidence and the petition are ready for review. And the respondent in this case, the entity that's going to be reviewing your petition and the evidence, is the Department of Health and Human Services, and they're represented by an attorney from the Department of Justice. So once we file that Statement of Completion, somebody from HHS, or the Department of Health and Human Services, will be assigned to review your petition and review the evidence that we've filed in support of the petition. Now, unfortunately, this process can take quite some time, and what we've experienced is that there's a backlog right now of cases that goes from a year to 2 years for them to actually review the information that we've submitted to them. Eventually, they will review the petition, they will review the medical evidence, and they'll file what we call a Rule 4 report. And this report is their assessment of your petition and the evidence. They will do one of two things. They will either concede that the vaccine caused your injury, or they will dispute that the vaccine caused your injury. Now, if they concede that the vaccine caused your injury, that signals the end of what we call the entitlement phase, where we are trying to determine whether you are entitled to compensation. If they concede that fact, we've made it through that phase, and that phase is completed. If they dispute that the vaccine caused your injury, that does not mean the case is over. All it means is that the judge that's been assigned to the case will have to hear arguments on either side, from HHS and from ourselves, as to whether or not you're entitled to compensation. Now, that can come via a hearing, that can come via a brief or a motion, but ultimately the judge is going to decide whether we've satisfied our burden to show that you're entitled to compensation. In other words, that the vaccine caused your injury. Okay, so now, after either the government concedes that your vaccine caused the injury, or a judge finds that you're entitled to compensation, the next question that needs to be answered is how much compensation? And we call this the damages phase. And generally, the compensation that is available to an injured petitioner includes any out-of-pocket, unreimbursed medical expenses. So any coinsurance payments, deductibles, any medical equipment that you have to buy, anything out-of-pocket, travel expenses, any of that stuff is reimbursable under the Act. The other thing that's compensable is lost earnings or wages. So if you have to miss time from work and it's related to this, to the vaccine injury, then any lost wages or earnings are also compensable. Pain and suffering is also a part of your damages, and there's no formula that the court uses to come to a conclusion, as to what you're entitled to as far as pain and suffering is concerned. But what they're trying to do is compensate you for the severity of your injury. So somebody that has had extensive treatment, gone through a lot of pain, a lot of physical therapy, and maybe they still, even after they're discharged from therapy, have some residual symptoms. That's a significant injury that requires a lot of compensation for pain and suffering. If, on the other hand, you have an injury that maybe persists for a little over 6 months, and you're basically back to your pre-injury status after treatment, that's going to be compensated on the lower end in pain and suffering. But it's a wide spectrum, and the court will look at medical records, they'll look at your testimony, and they'll try to come up with something that compensates you for your pain and suffering. And then finally, there's compensation for future medical expenses. And again, This is if that any future medical expenses that's not going to be covered by health insurance. So if you have an injury that's permanent, that's going to require some kind of future medical, they will take that into consideration and try and compensate you for that. So those are the four, in general, those are the four categories of damages that are available to you. And again, during the pendency of your case, we can engage in discussions with the government about these damages, try to come to a resolution without the need for a hearing or for the judge's intervention. But if we feel that they're not offering what we feel is the value of your case, we always have the option to go in front of the judge and request a hearing, have him or her decide what the value of these damages are, and award you that compensation in a decision. So as I said before, this is a long process, and what we do is we try to obviously get you to the point where there's a decision that you're entitled to compensation. From that point, then we determine how much compensation you're entitled to. Now, at any point along this process, the Department of Justice or HHS may approach us to discuss settlement or a mediation of your case. And that's something that obviously we will discuss with the client and determine whether it's the best route to go. But often a settlement, especially if we haven't made it through the entitlement phase yet, involves accepting something less than what we feel is the true value of the case and the true extent of your injury. So we prefer to try to resolve these cases by pushing it towards trial or pushing it towards a hearing before the special master. And we always have the option to have the special master or the judge decide, number one, whether or not you're entitled to compensation, and number two, what the extent of your compensation should be. We do not have to accept what the DOJ or HHS decides or determines what they're willing to offer you in a settlement. So that's something that we discuss with the client, and we always do what's in the best interest of the client. But we are trial attorneys. We're not going to accept something where we feel that you're not getting full value for your case. So if the case proceeds that way, we will pursue a hearing. We will pursue a decision from the special master if we feel that's the right thing to do. If you or a loved one has experienced an injury or a side effect due to a vaccine, I'd encourage you to call us for a free consultation or a free case review. You can do that by calling us at 312-578-9501 or by clicking the link in the description below.